It is a common complaint of bereaved families that they feel that their loved one may have been demonized after their death, or that they, the family, have been subjected to inappropriately hostile or aggressive questioning at a hearing. That is, of course, never appropriate. While robust and challenging questions may be appropriate on behalf of any party at an inquest, aggressive and hostile questioning is not, and has been extremely harmful to bereaved families in past cases, adding a huge toil to an already intolerable situation for them. Through all of your work, you will need at all times, of course, to understand and stay on top of relevant coronial case law and procedure, ensure your clients understand at each stage what is happening and what their realistic options are, deliver your advice calmly, kindly, and clearly, exercising sensitivity and common sense, and being prepared to go over points repeatedly as necessary. You will always need to remember that everything in an inquest has the potential to a bereaved family to be re-traumatizing. This ranges from the very obvious, such as ensuring that they do not inadvertently see upsetting material if they have chosen not to do so, to protecting them outside the court from insensitive behaviour. For example, barristers for interested persons were overheard by my young client chatting about the upcoming school holidays for their children and where they were going to go on holiday when she had recently lost her younger sister. Or sitting outside a coroner's court with a bereaved mother where there were no private rooms available, which is not an uncommon problem, and a barrister for the state refused to move elsewhere to eat his lunch, requiring the family to move. Or one bereaved family that spotted a lawyer in court researching potential holiday destinations. Be mindful of how the bereaved family would like their loved one referred to during the case, and make sure everyone sticks to it. If the family would like a photograph presented of their loved one, be prepared to push hard for it. And if you're acting for the state, don't unreasonably object to that. Ensure that a client with any particular challenges or disabilities that might affect their ability to follow the proceedings is fully supported to have appropriate arrangements made for them well in advance. As the solicitor representing the family, you will need to be prepared to handle practical situations like these, as well as more challenging questions of law and evidence. For families that are unrepresented, which is likely to remain a common situation as long as there is such limited funding available, there is no one to stand up for them. And it is vitally important that lawyers that are involved for other interested persons remain acutely aware at all time of the potential harm that can be caused.